Welcome to the Supreme Court. I am Lady Arden. I'm a Justice of the Supreme Court, and I'm going to summarize for you the judgments which the Supreme Court is issuing today in the appeal of Lehtimaki and Cooper. This appeal is about a charitable company. The charity is called the Children's Investment Fund Foundation UK, and I will refer to it as CIFF. CIFF was set up by Sir Christopher Hohn and Ms. Jamie Cooper, his then wife. CIFF is a substantial charity with assets of 3.8 billion, and it helps children in developing countries. Charitable companies are normally registered companies limited by guarantee. That means that its members have no interest in the assets. CIFF has only 3 members, Sir Christopher, Ms. Cooper, and Dr. Lehtimaki. There is a large board of trustees who are directors of CIFF for company law purposes and manage its affairs on a day-to-day basis. The relationship between Sir Christopher and Ms. Cooper broke down and the parties were divorced. There were serious difficulties running the charity because of internal differences of opinion. To resolve these difficulties, the parties agreed that CIFF would make a grant of $360 million to a new charity founded by Ms. Cooper called Big Win Philanthropy. Ms. Cooper would also resign as a director and trustee of CIFF. To make the grant, CIFF needed to comply with the Companies Act 2006. As trustees of charitable companies count as directors for company law purposes, it had to comply with company law. Section 217 of the Companies Act 2006 required the grant to be disclosed to and approved by the members of CIFF, because it was a payment in connection with the retirement from office of a director, that is, Ms. Cooper. So there had to be a resolution of the members of CIFF approving the grant, which I'm going to call the resolution. And to repeat, the important point to note is that it was a resolution which had to be passed by the members of CIFF. There were only 3 members, but 2 of them, Sir Christopher and Ms. Cooper, had conflicts of interest, and so it was decided they would not vote on the resolution. That left Dr. Lehtimaki as the sole person able to vote on the resolution. The grant also had to be approved by the charities regulator, the Charity Commission. The Charity Commission required the trustees first to apply to the court for its approval. The trustees made this application and surrendered that is the trustees' discretion to the court for the court to exercise. Dr. Lehtimaki was made a party to these proceedings. The Chancellor of the High Court, Sir Geoffrey Voss, heard the trustees' case. He determined that he should exercise the trustees' discretion by approving the grant, but he accepted that a reasonable fiduciary could disagree with that conclusion. That gave rise to the following difficulty. Dr. Lehtimaki did not consider that the order of the Chancellor bound him as a member also to vote in favour of the resolution. Dr. Lehtimaki stated that he would exercise his power to vote on the resolution whilst he considered in what he considered to be the best interests of the charity, which is what a fiduciary must do. But he had not decided whether this meant that he would vote for or against the resolution. His actual voting intentions have never been made clear in these proceedings. The Chancellor held that Dr. Lehtimaki was a fiduciary for CIFF. The duty of a fiduciary was to act in what he, the trustee, the fiduciary, considered to be in the best interests of CIFF. The Chancellor held that once the court had decided that the grant was in the best interests of the charity, Dr. Lehtimaki no longer had a free vote. That is, the vote to decide for himself what was in the best interests of CIFF. Dr. Lehtimaki had to pass the resolution. So the Chancellor made an order against Dr. Lehtimaki that he should vote in favour of the resolution. There was an appeal to the Court of Appeal of England and Wales, who agreed that Dr. Lehtimaki was a fiduciary, but did not agree that the court should make an order against Dr. Lehtimaki as to how he should vote. Ms. Cooper then appealed to the Supreme Court from the Court of Appeal. She sought an order that Dr. Lehtimaki should vote in favour of the resolution. Dr. Lehtimaki and Sir Christopher contended that, firstly, no such order could be made as a member is not a fiduciary. Secondly, that if the member was a fiduciary, then there was a principle of trust and charity law that the court does not generally intervene in the exercise of a fiduciary's discretion unless he is acting improperly or unreasonably. That is the so-called non-intervention principle. And Dr. Lehtimaki had assured the court he would not act in breach of duty. And thirdly, that the Companies Act 217 precluded the court from giving Dr. Lehtimaki a direction as to how he should vote. The Supreme Court has handed down its judgment, is issuing its judgment today on these issues. On issue 1, was Dr. Lehtimaki a fiduciary? Yes, 4 of the justices deal with the question whether Dr. Lehtimaki was a fiduciary. I give the judgment on this issue, with which the 3 other justices agree. We hold that a fiduciary is someone who owes a single-minded duty of loyalty, and that Dr. Lehtimaki was a fiduciary. A member cannot use his powers in relation to the resolution otherwise than for the benefit of the charity. On the question what the fiduciary duty means for members, the 4 justices went on to clarify the position by holding that what the member is entitled or bound to do is informed by the company's constitution and applicable legislation. The Charity Commission has for many years expressed the view in public guidance that members of charities are fiduciaries, and this ruling should not cause great surprise. On issue 2, could Lehtimaki be directed to vote in favour of the resolution as a matter of trust and charity law? Answer, yes. The court could make an order against Dr. Lehtimaki directing him to vote in favour of the resolution, but the 4 justices who deal with this issue were not agreed as to the reasons for making this order. On this question, 3 of the justices, for reasons set out in the concurring judgment of Lord Briggs, hold, as the Chancellor had done, that it would be a breach of duty for Dr. Lehtimaki not to vote in favour of the resolution after the court had approved the grant. At that point, there is no longer in their judgment any room for reasonable debate. Lord Briggs recognises that to some extent his route involves treating the fiduciary duty as objective rather than purely subjective. A purely subjective duty is one which requires the fiduciary to act in the manner in which he reasonably considers to be the charity's best interests. I am the 4th Justice, and I reach the same conclusion, but without holding that there is a breach of duty in these circumstances. The majority's view involves a departure from the principle that the duty of the fiduciary is subjective. Moreover, traditionally, courts do not intervene in the way fiduciaries exercise their discretion, unless they act or threaten to act in breach of duty, and unless there are exceptional circumstances. I take the view that exceptional circumstances are present here because of the existential threat to CIFF as a result of the disagreement over the governance of the charity caused by the breakdown in the relationship between Sir Christopher and Miss Cooper. The subjective approach should, in my view, be maintained because it is supported by strong judicial policy reasons, such as that of encouraging people to be charity trustees. Accordingly, the court should not intervene, in my view, in the way that fiduciary chooses to exercise his discretion unless there is evidence of a breach of duty on a conventional basis or other exceptional circumstances. In the end, the 4 justices who deal with this point consider that the court should order Dr. Lehtimaki to vote in favour of the resolution. The third issue is whether Section 217 of the Companies Act 2006 prevents the court from making an order requiring the member to vote in a particular way on the resolution. The argument is that charities operate in public law, and the public law principle should be applied that the court does not substitute its judgment for that of the decision maker. The 4 justices consider that the public law analogy does not apply to an internal matter of a charitable company. Lord Reed, President of the Supreme Court, the 5th member of the court on this appeal, states that in his judgment that he was more convinced by the arguments on behalf of Sir Christopher and Dr. Lehtimaki than the other justices, but he concurs with the order proposed because in his judgment the facts of the case are unlikely to recur. In conclusion, this court allows the appeal to the extent that I have explained. It differs from the Court of Appeal on the question of a direction against Dr. Lehtimaki, but it agrees with the Court of Appeal on a point which is important for the future, namely that members of charitable companies are in principle fiduciaries. Thank you.